Дякую.
Він одягається на лише. Одягається. Так само і у вас.
Я свій
Просто зараз дивіться, тут просто є регулювання гучності. І дуже є бажано, щоб ви його не підсовували під мікрофон, бо буде підляє, буде воно все свистіти і гудіти.
Поняв.
Стас, у нас идут часы, потом это видос на 53 секунды, потом вас выводят, потом с минуты.
Зараз часи.
Часы,
Так,
вот
зараз пішов годинничок, ви його бачите і там, і тут.
Запис іде цього чи тільки
Так, це
трансляція?
прямий ефір.
Ні, а запис є?
І запис є.
Запис так,
Запис
все.
двох версій англійською.
Окей.
Так, годинник.
Годинник, відос на 53 секунди, потім вас виводять, у вас хвилина мовчання, і потім...
Сказали, що я спочатку представляю всіх.
Все, хорошо, ну то есть якби після ролика вас виводять і тоді працюють.
Добре.
Все, тоді вже як ви демократи.
Поняв. Це колегіальна позиція.
Greetings to everybody. We are going to launch a marathon which was arranged by 5 a.m. Coalition, which is dedicated to Russian aggression, hybrid aggression, which started 10 years ago with Maidan, or Revolution of Dignity. Today we are going to have 4 panel discussions, and the first panel is dedicated to the Revolution of Dignity, the second is dedicated to Crimea, the third one is about the east of Ukraine, and then the full-scale invasion of Russians into Ukraine. We are going to start with Maidan. 10 years ago, I believe the very crucial event in the history of Ukraine happened when at Institutska Street, 48 people were shot dead, and we as citizens and we as the state turned the direction of our movement, not towards Russia. And I hope we will never go back to that vector of our development. And it would be correct to mention that we as society didn't have time in order to comprehend, to understand what was going on, to live through what was happening, and to understand for ourselves to what extent those events influenced us and our state. So today we are going to discuss it a little bit. I would like to introduce people who are going to be with us today, our dear experts who will be discussing Maidan, the Revolution of Dignity. Olena Storozhuk, lawyer of the victims of the case of shootings of Euromaidan participants, representative of the Lawyers Advisory Group, representative of Ukrainian military, Oleksiy Donsky, head of the Department for Maidan Affairs of the Office of the Prosecutor General of Ukraine, and Mr. Yuriy Aksenin, son of Vasyl Aksenin, killed on Maidan, and head of Association of the Heavenly Hundred, and Olha Vasyl is about to join us, the deputy head of the Revolution of Dignity Museum. We are looking forward to have her with us. We strongly hope she'll join us a bit later. And I would like us to commemorate everybody who died 10 years ago with a moment of silence. Thank you so much. Well, I actually have a question to all three of you. It's quite a general one, nevertheless. Did you already comprehend what Maidan was for you and for Mr. Oleksiy Donsky? I have yet another question. Well, because we already have the ruling of the court as regards shootings at Institutska Street. Mr. Oleksiy Donsky, do you agree with the statement that citizens had a right to have a riot against the against Yanukovych, who wanted to have all the power in his hands? Let us start with you then. Take the microphone, please. Good morning once again. Well, speaking about the question Mr. Stas, you've started with, well, actually, we shall not be mixing two notions here, the right to riot and the fact of this riot. Speaking about the right to riot, to be against somebody, to be rallying against somebody, well, everybody has got the right, I have no doubt, with due account of the events. And on February 20th, the society got its clear-cut right as well. Because actually we were dealing with people who did what they want, and they were indiscriminately using violence against common citizens. But actually, whether the riot actually took place as of the 20th of February 2014, and I'm not going to give any political assessments here, but legal ones, as the prosecutor and as the person who was investigating, who was looking into these events, I believe that actually there was no riot as of February 20, and there are various definitions of this notion we can find in literature, and there is a more common approach to understanding of this term. But actually, all the definitions mention mention specific signs which would characterize this very event as a riot. So one of these signs would be people who organize themselves, who are armed, and whose aim is to actually forcefully win the authority. So it was not happening in Ukraine, and there were no mottos like that, winning the power with weapons, at least before the shootings of February 20. I've never heard that in order to take the power using arms. There were some separate facts of weapons being used against the representatives of law enforcement. They were really isolated, and they were not the trend, and they were not properly organized into some separate movement, so to say. And actually, if we have a look at the ruling of the court, we will go into more details, right? Yep. But it's not mentioned there as well. So I paid attention to this very thing, that later on, they started mixing these two notions, the right to protests and the actual protests. So there was the right, but the actual riot protest didn't take place. Mr. Yuriy, what was Maidan for you, and did you understand for yourself in what way Maidan influenced you, society? Oh, and Ms. Olha joined us, Deputy Director General of the Revolution of Dignity Museum. Let me interrupt your answer for a second, and I'm going to repeat the question. Did you understand for yourself what Maidan was for you personally, and in what way it influenced the society? I beg your pardon, Mr. Yuriy. Yes, hello once again. So Maidan was no return point. That was that boiling point. And if you reach it, I actually reached it, and I started looking at the history, and I started gaining understanding what was going on. Well, actually, you know, I gained this understanding earlier than 10 years after Maidan, but right you are. I personally had this desire to go to Maidan and to counter the representatives of law enforcement, because those people were taking an oath to protect people of Ukraine. And well, people who were 40, 50 plus, they already understood what they were fighting against customs union, against the significant changes in the policy of our country. So actually, what's going on now was easily forecasted 10 years ago, and I believe we will still achieve the justice. And Ms. Olha, you as a representative of the Museum of the Revolution of Dignity. Yeah, you know, Maidan was quite a global event, a very comprehensive, very multifaceted phenomena. Maidan was not just against something. It was a space, a platform. It was the time when our nation was being shaped politically. Even the leaflets of Maidan, you know, because any riot, any protests would have some leaflets explaining the goals, the reasons for these protests. And at Maidan, there were so many leaflets and information material which offered explanation what these people were against, because, you know, they were against turning backs towards Euro integration, but they were for something. That was the place where the common vision of Ukrainian people was shaped, and the political nation was being shaped up. You know, people started understanding why they want to be the nation, in what way they want to build their country. And Maidan was not just a protest. It was a place where we commonly, jointly were creating a national idea of ours. And I believe it was a time and place when we shaped up this idea. Thank you so much, Ms. Evgenia Zakrevska. I agree with Olha. Actually, Maidan, it may sound as a paradox, but all the time, even after the first killings, the first shootings, it was a well-protected territory where you could create anything, actually, any processes, any democratic ideas could be expressed, any concepts were welcomed. There were so many discussions, and there were these analogues of roundtable discussions, which were strictly to the point, and people just meeting each other, just seeing each other, passing each other at Maidan. They were launching these very vital discussions, which became the foundation for the decisions which created the new state. It really started as the protest, then there was this camp stage, and then it became a real siege, as siege of Ukrainian Cossacks so many years ago. And actually, this was the response of the society to what was happening. The goal was changing, the requirements were changing, and actually people were changing their demands as the violence became more significant on the side of the representatives of law enforcement, and it was clearly seen, and there were some sociological studies which looked into this phenomena, and we were looking at this at the courts, and actually it resulted in a proper ruling. A very logical development of a protest, not just in terms of the protest itself, because actually at the court hearing we are looking more at that very part when the law enforcement agencies were countering the protesters and using force. But actually, in parallel, the new Ukrainian state was being shaped, was being created, and so many, how to put it right, political personalities grew there, and the idea of lustration or cleansing those at power and increased influence of the society, of the communities, and it all actually started at Maidan. It was not the protest against something. Sometimes it was also for something.
That was at the level of the actions of the law enforcement authorities. At the cross-section of these two platforms, there were certain requirements against something, but there were lots of them which were pro-something or for something. We did not formulate it or word it as against Russia. It was worded like against the dictatorship and violence of the police. But the essence was that thanks to that state of police, how it used to be, the impact of Russian Federation onto our state structures has become possible. Just because the vertical of power was created in this way, the penetration into the decision-making at the level of the state and strengthening of the tension of the protests and the increase of the use of force has become possible. What could be, but I'm not explaining it like that, but what could be explained like excessive use of force came to the very specific, well-organized action on destroying or killing your own citizens. At the moment, the majority of us did not word it just specifically against Russia. It was worded against the dictatorship, usurpation of the power, and violence by the police. Well, in fact, other way around. First, the violence of police if there is no response of the authorities and no response of the commanders of the police, there is no response of the state, the prosecutor's office, the legal system, the court system. There are no investigations of the cases of violence. If there is nothing which counters violence, it's everything like literally by Timothy Snyder, The Dictatorship Lessons. At the moment, the requirements are being radicalized, and every next requirement of the protesters is much more specific. The protesters were the most active but very representative part of the society, both representative by geographical principle and by the societal representation, and there were different professions of different level of welfare. It was the representation of all the layers of society which existed in the country. And still, as an outcome of Maidan, we specifically went away from the development of dictatorship and influence of Russian Federation. It was so specific that the next stage was the beginning of military aggression. Oleksiy, then I have the question for you about the response of the state. 10 years have passed since the shootings happened. So is this period of time enough to take them to responsibility? I'm not speaking about Berkut only, who were shooting or accomplishing any of the criminal acts, but is this period of time enough to take to liability the ones who gave these orders, to understand how these orders were given, and which of the crimes are still not investigated? Well, the question whether this period of time is enough could be very judgmental. I would say that during Maidan, more than 4,000 crimes were committed. Each of them is different by severity, by the complications to, in fact, provide the evidence of the forensic proof and the traces which were destroyed by the people interested. Who do you mean when you say interested people? Of course I mean law enforcement authorities. Just law enforcement? When we are speaking about the destroying of the evidence, only law enforcement authorities had access to it. But if we speak about the methodology of examining of the crime scene, whatever is in the notion of the, in fact, revelation, there should be primary documenting, and again, this is the question for the law enforcement. It was not a secret. Lots of documents were destroyed which did not allow to find direct connection to the people who had something to do with these crimes. Which documents do you mean? For instance, there was the video recording of these events. Lots of those video recordings should have been used later on, which were made by the journalists from the open sources. But as of the documents, just at the very basic level, to understand the dislocation of each of the law enforcement employees, we had to restore it in the investigative actions, though all of that should have been documented in the papers. The majority of those documents were not accessible. So coming back to your question, whether this time period is sufficient, it depends on the type of the crime we're speaking about. The substantial part of the crimes has already been in fact, solved. Can you be more specific about the figures? Well, I cannot be specific because if we speak about any episode of physical violence against the law enforcement, we are not only speaking about the ones who committed the crime, but also the organizers of different levels up to the top persons from the state. It was not the linear, it was the hierarchical crime. And if we found 5 or 10, in fact, perpetrators and found out who were the commanders, we cannot still say that the crime is fully solved. Let me reword it. You said there are 4,000 crimes. How many of them are in trial now, in the court, at the court level? Several thousands of them are in the courts already, but as of the number of people who are taken to liability, it can be different. At some of the crimes, the organizers of the low level are already taken into account. But it depends on the crime. We should speak specifically about each of them. On the 20th of February, let me say simply, on the 20th of February only, at the level of executioners, there is one ruling or verdict, and all the other Berkut policemen, their cases are still in court. We may say that at the level of executioners, we are identifying, and we have identified the persons who are responsible for that. As of the organizers and the, in fact, top persons who are responsible for that, those cases are in court. As of the 18th of February, the situation is much worse. Lots of murders are still not solved, though last year, as of the 3 cases of murder, there was criminal liability of the heads of Lviv Berkut units. The head of Lviv Berkut and the deputy head of the staff are now under custody as of the murders of the 18th February. But there are lots of gaps and lots of murders are still not solved. If we take the first murder on the 22nd of January, the first murder of Yuriy Verbitsky is in fact solved, and we have the ruling which still is not acting, but we've got lots of cases in the courts about the organizers of this crime, but the murders of Nigoyan and Zhizhnevsky and Senek are still not solved. Of course, we do not take the responsibility of us, because we are dealing with these cases for 10 years already. But I'm speaking about the investigative picture and in fact, the organization of the examination of the crime scene and primary documentation were lost. Yuri, the question to you. First of all, as the head of the Union of Families of Heavenly Hundred, is 10 years enough to at least take to liability at least part of them? Unfortunately, lots of the mothers and fathers did not even live till this ruling. No one is going to agree with this ruling because we have some of the Berkut who were already excused, and in fact, in 100 of years, nobody will get into the essence. Do you speak about the rulings on the shootings at Institutska Street? Yes, the 20th of February. There is the sentence where we had, in fact, the justification of the Berkut police officer as of these murders. We do not agree with that. So we dispute this case. I would like to ask the representative of the museum, Olga. As far as I know, you collected some of the artifacts during these 10 years. Yes. We cannot collect artifacts which are the evidence base. Obviously, the museum is some objects, and we are telling about Maidan with the help of the objects. Not far from here, we have the exhibition about the Heavenly Hundred, and we are grateful to the investigators because they provided us with some of the valuable exhibits. Which of them, if not a secret? Well, the one which I remember most of all is the passport of Mykola Dziavulski and his helmet. We have the pictures where we can see him in this helmet. Just imagine how the story about this teacher will sound. He was an educator, a teacher from Shepetivka town. How demonstrative it's for the people when they see the story of the person and they see the passport with the bullet hole, and they see this gray-mustached person who is very nice, and he went on the 20th of February there, understanding that it is highly probable that he can perish there, he can die there. The person who taught patriotism during his lifetime to the children. The people who are coming to visit our exhibition in the Museum of History of Kiev here to the just across the street from our event, after the exhibition people have tears in their eyes, because it's not just about reading the story, it's not about reading and seeing the original pictures which we have, which are numerous in our archive. Those objects are very representative. They are not only the evidence for the investigation, but for the proper understanding of what has really taken place. Evgenia, the question for you as the representative of the victims. As far as I know, the lawyers group has done a huge amount of work during these years. What do you think? Is 10 years enough to bring people to accountability, to find the connections, not only the executioners, but the organizers? Well, look, as during these 10 years we have the verdict on the most high-scale and the most complicated case which we had during all of these times, as for the shooting at Institutska Street, the answer is yes, it could have been done. And looking at this court trial, we can see how it can be done. But it was not done by the vast majority, almost 100 of other courts which considered the Maidan cases. So the organization of the court trial is on the court. So the influence on the participants of the court trial and the discipline of theirs is the responsibility of the court. The management of the court trial is the responsibility of the court. Every judge knows the times of bringing to liability or accountability. Every judge knows the significance of the case for the society. Every judge on his or her own chooses whether they have the proceedings and the hearings every day or twice a week or twice a year. It's obvious that if the case is considered only twice a year, 10 years and even 100 years wouldn't be enough. It would mean that the case is not planned to be solved. And the vast majority of judges had this very approach to this process. Well, except some of the objective circumstances. Someone got married, someone unfortunately died. Thankfully, some had to have a maternity leave. Those can be totally different circumstances. Yes, the full-scale war started, well, sorry, it started only 2 years ago. It did not start before, but it was not helping, in fact. We offered different ways. The information that the courts don't start the consideration of the cases when the preparatory stage of the hearing lasts for 5 years. Could you name some specific cases when it happened like that? Yes, sure, that was about a case on Euromaidan, on the beating at Shore Street, on the prosecution of the yellow bus in Kriposny by Lane. Those are the events of January 2014. That was about the cases on the 18th of February. The same happened on the case even on Verbitsky. So a huge amount of work was done by the prosecutor's office when they were countering this negligence by the court system. Well, not only in all of the cases, of course. There was more than one case considered in different courts, but what was considered in Kyiv, I would say it was... You cannot treat any cases like that, let alone such important ones. So my answer is definitely yes. At least at the first level, the level of executioners and commanders, it could have been done. And some of them were done, because the complication of the cases on the shooting at Institutska Street on the 20th of February is much higher than 80% of the cases which are still not considered even up to the middle of the case. And besides the direct responsibility of the judges, I still consider that the court, well, not vertical, but the court power, the organization of the court, well, in fact, legal system, they did not work enough. They did not respond to our proposals about the changes of the workload for the judges, to take into account the multi-episode complicated cases. And it should have been done in the same way as one episode case or just a theft. They need to spend more time on that to have a fair distribution of workload between the courts and to take this workload into account when we select the, in fact, the jurisdiction, and the Supreme Court should have taken that into account. I think that this is, in fact, the fiasco of the court system, because the majority of the cases are investigated and given to the court, except the episodes of the 18th of February and episodes of January. 3 murders of January, which were mentioned by Oleksiy above. But why it's so horrible that those cases are still not investigated, as the first stage is important as well. Even if we don't have the sentence, but we understand what has taken place, at least in the units. Our response to the question what really took place in January 22nd, 2014 is at the level, at least, that those were the law enforcement authorities shooting, not the protesters. It is important as well, but it's not enough, because we cannot even take lots of important decisions about the further life of ours. As of the events of the 18th of February, when people were beaten to death, do you mean when the peaceful march was dispersed? Yes, in Mariinsky Park, and then along Institutska Street, when the elderly people were beaten, they were kicked by the law enforcement or by Berkut. I don't know by whom, but it's important for me to know by whom. Just a moment, let me add. When there was, in fact, the crowding at the barricades and 2 people were, unfortunately, they died there, though they were kicked to death. At least here we understand that we have the video, and it is again considered to be...
Я не знаю, вони найжорстокіші, напевно.
And it is still considered to be cardiac insufficiency. Well, sorry, it is even more cruel to beat the person, to kick the person to death. And we don't see it even in the indictment. It is not described. It is really bad. This is the drawback of the investigation and the prosecutor's office. All the rest is the drawback of the court system.
Mr. Oleksiy, maybe you can answer this very question. Well, what prevents the investigators from looking into these very episodes? What's the problem there? Well, nothing prevents them from. That's not the term which we shall be using. Well, speaking about these episodes, there were 2 key things to be mentioned here. Well, the huge amount of law enforcement representatives who were there back then, and in general, 99% of the law enforcement representatives are not cooperative, meaning in order to identify specific people who committed the crime, well, it's practically impossible. They don't cooperate, and there is nobody who can point a finger at a person like that. And this being the case, we can just find the guilty person by way of interviews or interrogations. And usually whenever we're interviewing the representatives of law enforcement, they say, I didn't see anything. And second of all, what was mentioned by Ms. Yevgenia, well, it's really so. She's really right in her statement. Speaking about this very episodes, the key thing in general, in order to hold a person liable for shooting, for killing, for inflicting some bodily injuries, would be expertise. And the primary expertise, which was conducted back then, resulted in the reason of death, as Ms. Yevgenia said, heart insufficiency, some cardiac problems. I understand that the beatings were the reasons, but in order to hold these people liable, like conditionally speaking, even let me have an analogy here. If to have a look at Verbitsky case, actually he was frozen to death, and we are still prosecuting the law enforcers because we had a look at the case more thoroughly, and we've registered why this freezing happened, because actually the person was frozen to death. Speaking about the events of the 18th of February, it's difficult to have a look at all the events really comprehensively. Like this heart attack happened as a result of certain beatings, of certain actions, then it would be easier for us to qualify. Well, it's very important to clarify one thing here. Yes, to identify a specific person, that's very difficult. But actually, to understand that the special ops representatives were just stepping on a person and this person died, well, that's obvious. And we have so many videos, so many pictures, photos, which allow us understanding the sequence of the events. Some people were severely beaten up and some lost consciousness, fainted, and they were lying in the snow. 2 people don't stand up. They are lying there dead. So actually we understand what was preceding what and what was happening after which actions. We see these elderly people with great injuries, for example, head injuries, and they die not even resuming consciousness in the surgical department. That's also heavy bodily injuries, which resulted in death. We need to speak up about it, and that's very important for the relatives of these victims and survivors of Maidan. Several victims who were shot, well, at least that's easy to understand that they were killed by the representatives of the law enforcement, but actually there were these reasonings that, well, that was just a heart failure, that's it. Nonsense. Okay, then I have a question. Is there such a thing as collective responsibility? We know that this very unit of the special troops had beaten people up to death. Will it be possible to hold these people liable, and what for? Well, you know, the collective responsibility, there's no such a notion in criminal law. There's the responsibility of people who were acting as members of a group. And when we know that actually, like this Berkut special unit, they were supporting each other in their actions. Those were well-agreed actions. And in this format, it doesn't matter who was triggering the gun. Well, okay, but if a law enforcement representative is saying, I didn't kill anybody, I was just standing next to the person who did, well, it all depends. Yeah, but you know, this being the case, people died. Okay, if his colleague killed the person, if that's a well-verified fact that the person from his or her unit were committing this crime and they were standing next to this person for a certain period of time and enabled these actions by their presence and failure to act, then yes, they are also to be blamed. Well, if they flee from the scene, that's the other event, and if they were standing next to the person committing these crimes, if their colleagues were actually using the violence against civilians, then they co-committed the crime, no doubt. Okay, Ms. Yevgenia, and then I have a question to Mr. Yuriy. I wanted to go back to the sentence on the shootings at Institutska Street. Well, there are 2 global things to be mentioned. Right you are. There's the presumption of innocence in our concept of the law. That's something basic for all the criminal cases. And by the way, when the cases are considered by International Criminal Court, ICC, they follow a slightly different concept. They also have an exception from the presumption of innocence. If a person is occupying certain position, have got an opportunity to influence the situation, to influence what's happening, have got the tools to do that, then this person shall be proving that they didn't do this, that they are innocent. Meaning, if this was done under their control, with them being at power. This pertains to commanders of units, heads of states, you name it. But actually, there's no presumption of legitimate behavior of law enforcement officers who are there at the scene, who actually see what's going on, and they are sitting on their hands. They are not doing anything. For me, such a law enforcement officer shall not keep this position. They shall prove that they were not doing harm, that they helped the civilians in these cases using their bravery, etc. What did they do in order, A, to prevent this crime from being committed, and B, to help actually sentencing those who are to be blamed, because Mr. Prosecutor is mentioning here the truth. The law enforcement officers are not eager to cooperate. In the first place, militia, which is now police, and this tells us that that's a dangerous environment, and that's a dangerous group of people. They continue being dangerous if they, by their actions back then, allowed this to happen. And after, actually, they didn't help solving these crimes. So there's no presumption of goodness, of fitness, of militia officers, of special troops. They shall not be people in uniform starting from that very moment it happened. So this was not really supported when militia was turned into police, or in the course of lustration or cleansing of those at power and those occupying the state-financed positions. So this was somehow neglected. You know, for me to feel safe in this country, I need the law enforcement officers who were at Maidan to explain what was going on, what happened back then, for them to explain their actions or negligence to act, and only then I will try to understand that, yes, there are various events happening around you. Not everybody is a superhero. Not everybody can resist their armed colleagues, but they have to speak up. They shall not be just sitting silently in order to do the same in 5, in 10 years, because this was always their philosophy. So this danger is still out there, and this very danger, unfortunately, is, how to put it right? Well, we didn't overcome it yet. It's still there. I wanted to go back to the sentence for the shootings at Institutska Street. Mr. Yuriy in the first place, and then Ms. Olha. Mr. Yuriy, as far as I understand, the sentence as regards shootings at Institutska was not satisfactory to you, because former Berkut officers who stayed in Ukraine, one was acquitted and the second served the sentence in the places of the deprivation of liberty. Could you explain it a little? Yeah, you were mentioning actually the key problems. You know, I believe the huge amount of collaborators who are still there and who are still occupying the positions of power. Because if we look at the trace of Russia in Maidan cases, and actually investigators already had proven that the high officials, the top officials, were getting the orders from Russia. But actually, who would be these top officials and whether they are serving their sentences? I doubt it. And actually, was there a proper investigation within these 10 years? In every unfortunately office, starting from the water supply system company up to the presidential office, we have a collaborator. Like Ivan Bohuta was appointed the head of the Territorial Defense Force. Actually, this means that we appointed a person who was committing crimes, and he was the commander, and he was sending law enforcement officers to Maidan. So that's nonsense to me that he is becoming the commander of volunteers who decided to take weapons to their arms and, regardless of their civilian professions, started protecting and defending their country. So we can't be satisfied with this sentence, with this verdict. We clearly understand this is just the start, just the beginning, but we have to fight for the justice. I believe we shall not be shedding too much blood in that course. Ms. Olha, to what extent the sentences would help you to register the history of what was going on 10 years ago in Ukraine? Well, and whether that's important at all. Okay, have a look. Our institution has got a huge mission to tell the story of Maidan. And actually, there were the events, and then there is this historic memory, but there shall be something between these two notions. So actually, our museum is doing its best to preserve the historic memory, for this page of our history to be preserved. What's important here would be the trust towards what we are saying. We are not an organization spreading propaganda. We shall not be mentioning some untrustworthy information. Yesterday, we had a lecture, and actually, I was not spreading some myths, but on the contrary, I was actually answering some questions which were so difficult, so hard to answer. If we are interested in justice, we shall be answering all the questions. But there are some questions I have no answers to. I might have my own opinions, but I shall always have some sources, trustworthy sources of information in my hands. And actually, such sentences would be this important source of information, because this sentence captures everything that happened. And this way, we can assess the past based on this sentence. Otherwise, we are just mentioning some facts as we see them. Well, so having these sentences would be of paramount importance. But on the other hand, we were speaking about collective liability, collective responsibility. Well, that's possible. Maybe it's not possible within the judicial system, but our task here would be to shape up the demand for this collective responsibility. Yes, there are many people who have something to do with these crimes, but they were not committing these crimes with their bare hands. But whether they are liable, yes, they are. And are those people who were tolerating the crimes liable? Yes, they are. And that's the question to our educational institutions, to media, because actually we shall be creating the demand for this collective responsibility or liability. Okay, I have a question. I know that colleagues can correct me if I'm wrong. We've lost a certain number of cases of Maidan. Well, I would like to still mention a few words about the verdict, about the sentence, and then the statute of limitations. So, the colossal work was conducted by the court, and in that sentence, in that verdict, there are some positive and negative phenomena. We shall not be forgetting about the positive side of it all. Well, the sentence was not yet enforced, but actually it gave an answer to, it was not yet enforced, because there was still the appeal filed. Okay, but actually it crossed out all the speculations which were out there. A lot of fakes about Georgian snipers, about the third-party involvement. Actually, it demythified a lot of notions and statements. Now we know these were indiscriminate shellings, indiscriminate killings committed by the law enforcement officers, and they were following an illegitimate order. So this is something positive. That's an answer to the question, what was happening at Maidan? And this gives the assessment of these killings. The negative side of it all is there as well. For example, I don't have an answer to the question why court saying A about characteristics of these killings does not name it a terrorist act. They are not saying B. So, if we speak about the terrorism, the terror attacks, it would be indiscriminate killings with the goal of intimidating people. Well, that was the case, and that's obvious. How come the court didn't assess these killings as a terrorist act? Then speaking about these two people who were acquitted, One person was completely acquitted. The other was accused of actually using too much force beyond their mandate. So, speaking about using too much force, the court mentions that this person participated in the actions of the unit, and this approach contradicts the concept of criminal law as regards assessing such actions, and it contradicts the best practices of the Supreme Court and the conclusions of the Supreme Court. Because, for example, even if these people fail to act, this failure to act would be still agreed between everybody in the unit. And the last thing I want to mention, something you started with, I want to draw your attention to this revolt or uprising or protest, whatever we call it. The uniqueness of this sentence would be that we have yet another document accompanying the sentence which explains the terms. The court is explaining what they mean by a concrete barricade, by snow barricade. A very unique work was done here. Yes, but revolt or uprising, there are so many definitions of this notion, but what the court would understand under revolt or uprising, this is a very complicated term which may be understood differently. Well, the court is mentioning this term repeatedly, but it's not giving the definition of this very term, what they mean by this term, because there might be also, uprising, revolt, protest. We can call it by various terms which are a bit different. And the literature gives us various terms here. So if we're using such a term, and if we are actually providing the list of terms that are used within this sentence, it would be so important to actually mention what we mean by revolt or uprising. More important than to explain what we mean by the snow barricade. And this being the case, we can lose a case. Then speaking about the statute of limitations, let me tell you that this would be especially severe crimes, which would actually result in the life sentence. This would be what, murder? Yes, that's murder, that's the terrorist act, and they don't have the statute of limitation.
Where we have some of the crimes which do not foresee life sentence, their statute of limitations is 15 years. Besides that, the people who are in fact are still trying to hide, those are the top managers who fled from the country during even February of 2014, and the statute of limitation is not there as well. The problem is about the severe or crime. The statute is over today, after 10 years. Those cases which are under risk are 69 cases. But I'd like to drive your attention to one more tendency connected to that. Out of the 69 cases, we said there will be lots of them. As of today, 7 cases are closed. In 4, we have appeals, so they're still not considered by the court. So it's not a rehabilitating reason to close the case. It is possible only when the suspect does not mind to close the case. Among them, there are lots of acting law enforcement authorities, employees, which is an obstacle for their further service. So the issue is that the initiative is theirs now. They know that they will not have any punishment. If they don't want to close the case, there should be even the indictment so they will, thanks to the statute of limitations, they will be free. So at any period, they can say that by statute of limitations, they would like to close the case. Even if they have in fact, the ruling of the court, they still go on. Then there will be the appeal at any moment which they consider to be necessary. They can provide an appeal for closing the case. So while the verdict was by the court or the prosecutor, now they are who are defining the further fate of the case. This is the issue as well as the impunity, because even if we have the necessary ruling, they will not have any punishment. I have an additional question to Evgenia about that, because as there was the example about the ruling and the sentence on the shootings of at Institutska Street, some of them do not comply with the expectations of the society. But legality doesn't always mean justice, unfortunately. Have you read the ruling on Institutska Street? Let me come back to the statute of limitations issue. So as for holding accountable, and let me come back to the importance of the investigation and rulings of the court to preserve memory. Not only the rulings, the sentences are important, but also the materials of pre-trial investigation are important as well. And in the situations when we have verdicts and people are not taken to liability, are not held accountable, it's even worse than when the people who have held accountable, or so we wouldn't like to close the cases because of the statute of limitations. Of course, here we do not. It's not our prerogative. We cannot be an impediment on this process, but we are against that. We express, but even if we do not have the sentence, but because of the statute of limitation, it's really not a rehabilitating circumstance. We still have the indictment, we have the materials of the criminal case and the court case. Considering the experience of other countries, in particular Lithuania, we were closely researching the history of holding accountable for the shooting at the TV tower at the beginning of the restoration of independence of Lithuania. All of the materials, all of the case materials, all of the thousands of volumes and video recordings are all have been preserved between the court trials in the museum, and they had the first sentence just for that, like that, and it instantly got to the museum. Nobody was touching that case anymore, but then when Dalia Grybauskaite came to power, she was elected as president, it was obvious that they needed to come back to that. They needed to find out some of the issues and to bring this case to the court and to hold all of the perpetrators accountable. At the moment, this case was found in the museum. The whole case was preserved there. And after the ruling, it will get to museum again. It's logical, because whatever is collected, all the materials are at least the memory of the nation already. And to find out the precision, the place, to make it more significant, we need the proper assessment by the court. But even the prosecutor's assessment, the prosecutor office's assessment is also important. That is why it's bad that some of the crimes are not at least adequately described from the objective side, let alone the holding accountable. Just the objective circumstances of death, the cause and effect of death. Maybe we don't know who exactly was the one who kicked the person, but we need to document that it really took place, that the national police is responsible for that. They should be ashamed for that. But without proper rulings, it seems that it never took place, in fact. I have a very demonstrative point to confirm those words. Again, the exhibition, the earthly ways of Heavenly Hundred. We are telling about that, and after the excursion, a man came up to us and said, "You are saying that Antonina Dvorinets, the hero of Heavenly Hundred, but she died because of the heart failure. She is one of the two who died at the barricades." Of course, I have enough of knowledge to explain why is that, but I have to refer to the documents, and the person has his argument, and my words did not convince him. He needs a document, and at least a copy of this document should be an evidence in the museum. Thank you, Evgenia. And here we are also coming closer, approaching to the point of Oleksiy, that many of the law enforcement who are, in fact, in these cases are still acting. They are going on at the service. This situation should have never happened. It's not the question to the investigation, to the prosecutor's office, to the court. It is to the law enforcement system and what we say collective responsibility, but not criminal one. Moral responsibility and acknowledgement and self-cleansing of the system from what was done by their colleagues, and the assessment within the system of what was done by their colleagues. Because still we have the opinion prevailing that the powerful state is when the grassroots level police officer implements any order of his commander, and the same just along the whole vertical of power. No, it's not the strong state. The strong state is when the law enforcement are complying with the human rights. They value the legal orders and can see the difference between the legal and illegal ones, and will never shoot or kick the people of the country. This is the strong state. Because when the authorities, the resources are given without any control to the law enforcement, and this power is used however they would like it to be used, it may lead, and it hardly led, to the scenario which used to take place in Belarus. Their point of no return was in 2010. Our point of no return could be 2013, 2014. We repelled them, but we did not make the proper conclusions, because we did not understand what the danger was and how our own institutions and mechanisms have to counter our neighbor or any usurpant, and what is the danger here. We are really short of time already. Oleksiy, the question goes to you. During these 10 years, we heard a lot about the Russian traces, the Russian influence, Russian snipers or not Russian snipers, any snipers, about the FSB, in fact, employees who change their clothes. Just first of all, I would ask you to mention your favorite myth about Maidan, and could you please highlight, in fact, the influence of Russia, whether we had really FSB agents at Institutska Street. Stas, just yesterday I commented on that, and I was amazed that I was not heard properly by the journalists. In a nutshell, I may say that as of today, the proved is the fact that Russian hybrid aggression has started in November 2013. On the 30th of November 2013, right. And let me tell about the forms of this aggression and how it was showing itself, but I understand that we are short of time. Still, this Russian hybrid aggression at the time was conducted through the Ukrainian power, the Ukrainian authorities, by the hands of the Ukrainian law enforcement authorities. The Ukrainian authorities, in particular law enforcement, were the executioners, the ones who provided this aggression. As for the Russian snipers and FSB agents, these are all myths. Russian Federation did not have any need on that, because unfortunately there were Ukrainian law enforcement authorities which that power could use to achieve the objectives which the Russian Federation had. As of FSB agents, there were FSB agents who did not try to fake their identity during January and February 2014. They came to Ukraine, and together with the security service employees, their function was, first of all, to consult about the actions which have to be implemented. So they were the consultant. Yes, they consulted the security service. Yes, that's true. And we can definitely say about that. But speaking about consultations, we can speak about the head of the level of the heads of the institutions. This is about the key cases and the organizers of the crimes. The contacts at the level of the Ministry of Interior during the active phase of the events. The contacts between the head of the security service and the Federal Security Service of Russia. This group of 20 people, in particular 5 FSB generals. When did they arrive here? In January. And they were met by the Ukrainian security service. They stayed in Pushcha-Voditsa at their, in fact, resort. And their idea was, look, if there was the propaganda objective, they wouldn't need FSB agents. They could have used journalists. Definitely, you do not need generals of FSB for that. Yes, you're right. And you don't need even to arrive to create some content. You may use other people, but in this case, this, unfortunately, well, kind of saboteur activity was to substantiate the illegal actions. It was the basis for the illegal actions of law enforcement against the protesters. If we speak about the influence forums, those were at the highest level for decision-making as of use of force, and in this case, I would like you to understand that on the 30th of November, the Russian Federation used this date as the point of no return. What do I mean? Before that, the Ukrainian authorities were in doubts. They were in between the Euro integration, then the customs union, then Euro integration again. They took the decisions which were excluding each other. But they needed some event which wouldn't give the opportunity for the Ukrainian authorities to deviate from one decision to another, but to act within the very specific Russian vector. This was the event of the 30th of November, which since the very beginning was considered to be the disperse of the protesters, but it was in fact the beating of the participants of the protest, so as further on the authorities were totally under the control or by the orders of Russian Federation and were acting only within them. That's the only point which can explain these discrepancies or debatable issues, because if you remember, during Maidan events, not a single law enforcement officer, even if he conducted the illegal actions, was not taken to liability, was not held accountable, except one episode, the events of the 30th November, when, if you remember, in December, Deputy Secretary of the National Security and Defense Council was taken. Yes, he was held accountable. Some investigations started, but there was no end of it, because after these events, the Ukrainian authorities were constantly compliant with the orders from Russia. There were lots of influence factors, but it was this kind of the breaking point, and first some of the people who were involved in this scenario were held accountable, but then of course they were acquitted. So the question is, do we have FSB agents in February, yes or no? We do not have such data. We're really short of time. I had one more question to Olga. how we could preserve memory about Maidan, because the Russians are still trying to rewrite our history. They tell that it was inspired by the United States, that the war was waged because of the Maidan events. So how can we counter that, preserving the memory, and how can we preserve it, in fact? There is such wording, the infrastructure of memory. It is working for the perspective of many years, because now 10 years passed and the memory of Maidan is becoming vague already. So we need the markers, we need kind of milestones, the stoppers, what exactly we'd like to emphasize and what should be documented and registered. Obviously, the outcomes of investigative actions are the source of this detailed information, because the most accessible source for us now is the media, this non-stop broadcast, which are the key evidence we are working with. We, as the Museum of Revolution of Dignity, are closely accumulating all the accessible information about the Maidan cases. We also have a separate sphere where we register that, we document all the accessible court hearings. It's very important as well, because we are told that we need to show both sides, that we need to give the voice to the different side. Okay, we say, the mic is open. You can come and state and make a statement. The other side doesn't want to make a statement, obviously. So for us, this source are the statements given in the courts. As of now, the investigative materials are not in access. So when I'm speaking about those markers, those milestones, which we need to provide for this memory not to become vague, not to disperse, if not the full-scale invasion, I hope that we would have the first stage of the opening of the full-scale exhibition of the revolution of the Museum of Revolution of Dignity. We need this space, and we can see how the war made that more relevant, because everybody understands what it started from. We need memorial places, and really we do not have the proper memorial in the center of the city, and it drives attention of the people who are into preservation of the memory. The materials of different people exist, and we take care about them, but those are temporary solutions. And again, if we do not install those markers, we can lose time and they will stop being relevant. People will forget, will lose this opportunity to define this event as a kind of pointer, which is the milestone which we focus upon when we perceive the future.
And for sure, the archives, they shall be there, they shall be accessible to the public. So this would be a kind of educational information spreading events, but also the huge research base. So we have just 10 minutes left. Do we have questions from the room? Please introduce yourself, who you are and whom you have question to. I'm Tetiana Pechonchik from Zmina, and I have a question to Evgenia Zakrevska. So, a question is as follows. It's clear that we are marking the 10 years anniversary. So symbolic when we want to speak about actually what are our successes and failures in holding people accountable. And if today we can mention the names and the family names of those who, well, that's clear. There are so many systemic things where we cannot single out a separate person. But if we could mention the family names of those who were sabotaging these cases, investigations of the cases, and who were sabotaging actually the firing of those law enforcement representatives who were at Maidan, and actually firing those judges who were ruling against the representatives of Maidan. If you could, who would these people be then? Well, you are mentioning correctly, this is a systemic phenomena. This is not one family name. If we speak about cleansing of the law enforcement system, then Arsen Avakov would be a separate family name. That was a huge mountain on the way to justice. He was doing everything possible to actually preserve the situation as it was, not allow it developing in any direction. And actually, he was protecting all the law enforcement officers for them not to be held accountable. This was his concept, not to have any sentences of the court. Nobody shall be fired. You are standing for me, I'm standing here for you. That's it. Let's forget about all the rest. And what I was struck by, 2014, let's go 10 years back. And we were speaking about creating a separate unit and concentrating all the cases in one separate place because, all the various types of law enforcement agencies were dealing with this case, and we were emphasizing at our meetings with the Prosecutor General and the Ministry of Interior, the SBU or State Security Service of Ukraine. There were first cases which landed in court Sadovnik, Ambroski, Zinchenko. And Yarema, the back then Prosecutor General, told us, well, that's nonsense. It can't be a real case. It can't be everybody. And he said, I won't give you anybody else. This is already too much. This is a direct quote. I heard these words, and I will never forgive him these words. And then he helped creating the Special Investigations Unit. So before quitting, he did it. That was the good thing. Speaking about something I can tell you in response to your question, but that's really something systemic. We can't be speaking about separate family names. We won't solve the problem if we just punish few persons. Do we have any further questions from the room? I don't see any. So, just to finalize the question of the statute of limitations, because I don't know whether we will be coming back to this issue. The thing is that in 5 years, we will actually go over the statute of limitation in absentia. We shall not be too relaxed now. And we lack yet another tool, yet another instrument, that's compensation to the survivors, because actually we need to take all the materials of the case and prove, without the prosecutor's office, prove all the events which happened, prove all the losses suffered. And now the state is actually burdening the survivors with this task. Previously, the prosecutor's office was dealing with this, but now, in order to get compensation and in order to, in general, somehow come to the truth and register this truth within the court hearing, this would all be on the shoulders of the survivors. And we need to do something with this. This is not a proper situation. This is not normal. If the state can't investigate a crime and can't bring a perpetrator to a liability, that's not correct. But in what way shall we prosecute the perpetrators because these cases were not a success? And how to avoid it? Well, we can't avoid it. Now we can just advise for the future, maybe advise it to some other country. We still have 15 years. No, we have just 5 years. Oh, yes, I mean in absentia cases. Okay, in order to consider this in absentia cases, at least those cases which are in court now, we need a completely different approach to prioritization of cases. Because if we speak about case of Yanukovych, and holding all other law enforcement officers liable from the black squad, right? They equal it to a petty theft from the supermarket. There's no culture in the among the participants of the court to prioritize the cases somehow. If this is one of the thousands of the cases on the hands of the judge, of the prosecutor, of the lawyer, it won't be considered properly. This is not the issue of the criminal procedural code, no, just the issue of time management. And we were mentioning this 5 years ago, but the approach didn't change. So the approach can be changed because we have this sentence already. We have this verdict. You mean the verdict on the shootings at Institutska Street? Yes, meaning this case can be considered, and there can be a proper ruling if there is a political will of the judge and the capacity to manage this process. You mentioned laws and bylaws which can influence this. Yes, I wanted to dwell upon it. I believe that we shall not be speaking about goodwill and consciousness of the judges. The prioritization mentioned by the previous speaker can be registered at the criminal code level even. You know, there's this abstract norm about the unbiasedness of the court hearing. We shall mention what the case shall look like if that's a high-profile case. Then speaking about the statute of limitations. Okay, since the notice of suspicion was served, there's a year. The prosecutor, the investigator shall direct this case to the court. Shall we have the same? Like 3 years, 5 years would be the term of consideration of the case in the court. I don't want this to be considered by the court forever, and I don't want it to be dependent on the goodwill of a separate judge. I want to actually have it properly put down. Oh, we had a question from the room. Yes, an additional question. What could help judges to be having these court hearings more often? Do we maybe lack demand of the society? Maybe media shall be more active. Maybe there shall be some observers who can help. And speaking about in absentia cases, is it possible introducing any changes to the legislation in order to actually not to go beyond the statute of limitations in 5 years? And whether there is a vision in what way the society, journalists, human rights advocates can join their efforts whenever there are any changes needed to be introduced into the legislation for us to be lobbying for this to happen. Who's going to answer first? Ms. Yevgenia. Speaking about the attention on the side of society, on the side of journalists, yes, that's of paramount importance, to tell you the truth. And this really changes the behavior of prosecutors, of judges, significantly, their attitude, and it adds to the priority of the case. It prioritizes it higher. So this is at the level of psychology, right? If this is a high-profile case, if it's obvious this is an important case, more resources will be allocated, more time will be allocated to consider this very case. If we speak about equal conditions, everybody wants to do something which can yield a result here and now, so to say, low-hanging fruit. So if Maidan case for society is something like petty theft, then the court, the judge will select that very theft because it's easier to deal with this case. And in order to draw the attention of the society, there shall be an openness of the court hearing. But unfortunately, well, you know, we actually had Maidan case considered by the court, and there were YouTube actually streamings from the court hearing. You mean shootings at Institutska Street? Yes, this very case. So it was on YouTube. But at certain point in time, and to be more specific, it was COVID and the quarantine. There's no COVID anymore, but courts didn't go back to the transparency they had before COVID. Actually, it's more convenient for them to live in this small world of theirs, to do it, quietly in their own corner. We need to deal with this. There shall be more of the open court hearings. Speaking about amendments to the Criminal Procedural Code, well, we will always be facing the fact that these are not just cases of Maidan, and we can be amending the Criminal Procedural Code, but still we are facing a shortage of human resources, like 2, 5, 10 judges per court. We can change the document, but we can't change the reality of Ukrainian courts lacking judges. If judges can't prioritize these very cases, if they don't know how to properly manage it all, the amendments of the Criminal Procedural Code won't save the day and won't solve this problem. We can exclude a certain, obstacles, but this shall be the liability of the judiciary system, full stop. We can't regulate it all in such a way just to actually say no to moral responsibility or turn this moral responsibility into the legal one. Mr. Yuriy and then Mr. Oleksiy. Yeah, just 1 second. I just wanted to mention what I meant when I said regulation of prioritization. This was mentioned by Ms. Yevgenia. For example, the judge has got so many cases, some scams, some robberies, etc. But there are other cases, and the statute of limitation is running up within those cases. So this would actually dictate the prioritization. This shall be somehow regulated properly. If that's a high-risk case, they shall be prioritized. Give the floor to Mr. Yuriy, I beg you. They are all within the, they are all quite risky cases, within the risk zone. Right now we understand if there are not 2 or 3 court hearings a week, we will go beyond the statute of limitations. Mr. Yuriy? If I may, the thing is that attention of the civil society, of mass media, can solve some issue there and then, but not always, right? And on a daily basis, there might be 6, 7 important cases, and journalists will lack time to cover that all. Me and my colleagues are trying to lobby a draft law, and we came to Verkhovna Rada with this draft law, and what we have now, the amendments which make it impossible for this draft law to become a law. They were bargaining with us. They offered some social guarantees for us to actually abandon our desire to stand our ground. It's like Svetoshino court has got court hearings at least 2 times a week. So many people died fighting for justice, and we are not achieving this justice here in peaceful Kyiv. We had a meeting on February 16 with the Prosecutor General, and he promised us if everything would be okay with that draft law, and if it doesn't prevent from the activities of any authorities, he will lobby it. So we strongly hope that there will be some changes, and they are coming. And any other questions? If no, yeah, they are asking me to cut it out and finish. Thank you for being with us, and thank you, dear experts. Thank you, dear interlocutors, for finding time today to come here. And then we are going to have a Crimea panel coming next. Be with us.